officer-involved shooting in Prescott with an unarmed individual. Was it a good shoot? Let's dive in. Hey guys, my name is attorney Brittany LaBerry and I'm here with attorney Rachel Moss, and we're going to analyze this new video that came out. This is a officer-involved shooting. We are going to look at a body-worn camera, so viewers beware, but we're going to dive in and see if this is a good shoot or not.
Yeah, I think we go ahead and just start by watching this video and letting everyone see what they think.
Absolutely, let's do it.
I don't have anything to say to you. I haven't committed a crime. I don't have anything to say to you. Step off my property, please.
Sir, you need to step away from the car. All right. I have one at 541, I have one at gunpoint. Put the bike down and come over here.
The officer orders Leslie not to enter the home. He ignores those commands, and that's when the officer fires his duty weapon.
You will get...
Okay, so in this video, what we see is Officer Brian Sutton responding to the scene. So he's responding to the home of an individual named Daniel Leslie. So this happened in Prescott, Arizona. So at this time, the officer was responding after a previous incident from the day before. So Mr. Leslie had previously been reported for a domestic violence incident. Not all the details are out, but what it really boils down to is that there was some threat by Leslie against his girlfriend, and it sounded like some attempt for Leslie to break into her RV. We know that he threatened to slit her throat, potentially, and so the officers had some sort of an idea about who Leslie is before they went into this situation. So after that incident, they had attempted to take Leslie into custody, and Leslie had attempted to flee the scene. And so officers then began a hot pursuit chasing Leslie. However, they deemed the hot pursuit too dangerous to the public to proceed. And so they stopped chasing Leslie that day. And then later this next day came back to try to interact with Leslie. And so this is where this incident occurs. So on this day, there was not an active crime occurring that we know of, at least. But the officers came in pretty hot, as we saw.
From the details that we can see at this point, we don't know what time the crime allegedly occurred the day before, but we do know that it was a full day after that. He just politely said, "I don't want to speak to you," invoking his Fifth Amendment rights, which you are allowed to do. He was wrestling in the car. At that point, I will say the officer could not see his hands, right? That's always a concern, is, make your hands visible. I don't want, you to feel or, look as a threat to the officers. But the officer doesn't pull out the firearm until he's actually away from the vehicle and his hands are visible. He's holding some sort of bike. So what do you think about that?
Yes, exactly what you said. Leslie followed instructions at first. So Leslie answered saying, "I'm not making any statements." That's absolutely within his rights under the Fifth Amendment. It's actually what we tell people to do all the time. Just shut up. He was following that advice. Nothing wrong with that. Just because someone says, "I'm not going to talk to you," doesn't mean the officer has to walk away. So the officer was still doing his job properly. The officer wanted to make sure he was safe, so he instructed Leslie to get away from the car. Completely understandable. We don't know. Leslie could have been reaching for a knife or a gun inside that car. Something that could have been a threat to the officer. So I think it was proper for the officer to ask him to step away from the car, and Leslie did so. But what happens next is where it becomes a bit of a problem. It's where Leslie stops following the officer's instructions. So at this point, the officer asks Leslie to not go into the home. He can tell Leslie is aiming to enter the house, and Leslie does not follow instructions. And then the officer says, "If you go into the home, I'll shoot." And then he almost cuts himself off by then shooting. He doesn't really even give Leslie the opportunity to hear that full warning, that full instruction. I will acknowledge that Leslie should have followed that officer's lawful order from the beginning. Leslie should have stopped when the officer told him to stop. However, does that justify the officer in using deadly physical force? I don't think so, for a few reasons. We have a couple things we're able to look at. I think we can start with Tennessee versus Garner.
So there is a case, as Rachel pointed out, Tennessee versus Garner, that is a Supreme Court decision. It was a civil case. The facts in that case was there was a burglary or an alleged burglary that was about to occur. A neighbor called 911. Police did respond. They saw the suspect fleeing. He was able to see his hands. Didn't look like he was armed. At least the officer said, "I don't believe he was armed," but he still shot him. And he unfortunately did pass away from that. The court held that that's not enough, right? Just because somebody is fleeing does not mean that you can use deadly physical force. There's a couple ways that you can as an officer, one being if they thought that there was imminent danger to the officer or a third party.
Yeah, so exactly. I think it's pretty easy when doing the step-by-step analysis. The first question, was it necessary to prevent escape? Here I could say, yeah, maybe the officer meets that first part. Leslie was far away from the officer. It's not like the officer could easily just grab Leslie. He wasn't in his car. They were on foot. Maybe using a firearm was necessary to prevent escape. However, that second prong of Garner is where we really have some concern here. Did he have probable cause to think that Leslie posed a significant threat of serious physical injury or death to himself or someone else? I think there's some arguments to be made. If I was the officer's attorney, there are some arguments that I would go to. However, I think my initial gut reaction as an attorney and just as a person in general is that no, it was not necessary here to prevent serious physical injury or death.
Yeah, absolutely. And look to the facts, the small ones that we know, right? Again, we don't know everything. We are kind of limited to our knowledge at this point because not much has been released. But we do know that a full 24 hours went by before the officer made any other contact, right? His mom was present. The officer did speak with the mom and he asked if anybody's in the house. And she said, yeah, a whole bunch of people. Nothing in the reports that I was able to see said that the officer knew of Daniel's history or, if he's committed some offenses before, if he has a record or if they've had run-ins with him to know that he's dangerous. I didn't see any of that information. Now that could be out there. Maybe the officer does have knowledge, but I didn't see it in any reports that I was able to look at. And his hands were visible the whole time, right? It's not that he was going in his pocket or pulling something from his back. He was clearly just trying to run, in my opinion, in the video.
Yeah, I think we can assume that the officer presumed he was unarmed here. He didn't see anything in his hands. Maybe the officer thought Leslie had something in his pocket or maybe
around the corner in the house, maybe.
Yeah, I could see where the officer could think that Leslie was going into the house to grab a weapon. The question is, does he have a strong basis to believe that or not? I do think there is some knowledge that the officer had that could make Daniel seem like a threat. I think the most obvious thing is the prior domestic violence report, the one that he had not yet been arrested for. So Daniel, we know, said that he basically threatened to slit his girlfriend's throat. That's
Allegedly
said that, but I'm allegedly pretty sure he said that. And if he did say that, that's definitely something to take seriously. That would make Daniel a threat. That would give me pause if I was an officer that Daniel would think about doing something.
Absolutely.
However, just because someone made a threat at some point in their past does not, I think, give them a permanent mark that anytime they're doing anything, they're going to be reaching for a weapon. I don't think we see that here. And I don't think the officer did enough research to know, did Daniel, when he make that threat, how serious was that threat? Did he actually have a weapon nearby or in his hand when he made that threat? Or was it just kind of one of those empty threats that people make in the heat of the moment? A terrible threat, something he should have never said, but did it really mean anything? The officer doesn't know all of these things. So I don't think that statement alone has enough weight behind it for the officer to then have probable cause to assume that he's going to go ahead and hurt someone if the officer doesn't shoot him and stop him from escaping.
I agree. I think under the Tennessee v. Garner Supreme Court case that it doesn't pass the test.
Yeah, and we see Daniel turn away, start to run. We don't know what he was planning on doing next. But there is a priority, towards officer safety a lot of times in our law. So we want our officers to stay safe. But this is one of those instances where there just, I think, wasn't quite enough for that officer to do what he did. I definitely empathize with Officer Sutton because when you're an officer, you're facing these split-second decisions that can be very, very difficult. And I think this is one of those situations where he has that knowledge that Leslie might have some sort of domestic violence history, might have made some sort of threats in the past. This is someone that is pretty combative from the bat. So Leslie is not following directions. He's giving the officer some attitude. I can see where the officer had some concern. However, I do not think it rose to that level yet. I think the other place we can look other than Tennessee versus Garner is also to the state-specific laws. So this happened in Arizona, which is our home turf. So we're attorneys licensed in Arizona, so we always love when we have an Arizona case we can analyze here. And in Arizona, there is a justification statute that applies specifically to law enforcement. It's Arizona Revised Statute 13410. And Section C is really the section we're going to be diving into today. So I'll just start by reading it.
Perfect.
So Section C says the use of deadly force by a peace officer against another is justified pursuant to Section 13409 only when the peace officer reasonably believes that it is necessary. And then they give a couple scenarios where it'd be necessary. The first is to defend himself or a third person from what the peace officer reasonably believes to be the use or imminent use of deadly physical force. So here I think we can strike off Section 1. This wasn't an incident where Leslie has shown any use of physical force. There isn't an imminent danger. If there is some danger of force, I would argue that it's not imminent here. As far as this officer sees and knows, Leslie is not holding some sort of weapon. There wasn't someone nearby that it looked like Leslie was trying to harm either.
Absolutely, I would agree with that. Also, I think, again, like we've mentioned earlier, the really important thing, too, in this video is that he's not grabbing towards his pants or anything like that, right? So I don't even think that he was reaching for something.
Exactly. Yeah. And then Section 2 also has its own 4 subsections to get into, but Section 2 says that it's necessary to effect an arrest or prevent the escape from custody of a person whom the peace officer reasonably believes. And then the first subsection is A, is committing or is attempting to commit a felony involving the use or a threatened use of a deadly weapon. So what do you think about that section?
Now, the whole reason why the officer did respond and was, making contact with Daniel Leslie at the time was because there was a 911 call that came in about a DV where he definitely threatened to use a deadly weapon. Now, do I think that matches the felony? No, I think that could be an assault, a misdemeanor in this case, right?
Or misdemeanor threatening and intimidating.
Yes. Now, something else that I don't think that we mentioned earlier is another fact to the case. When the officer did some investigation, he looked to the RV, which is where Daniel Leslie's girlfriend was staying at the time. They said they saw footprints on the RV, don't know where, and that they saw some sort of marking, I think close to the door, from what I would infer, that kind of looked like a hammer or hammer marks. I don't know, we didn't see pictures of it. I don't know where it was. I don't know if it was him, if that was already there, right? Or if Daniel would say that, no, he did not do that. But burglary or attempted burglary is a felony, right? So I don't know at the time if the officer knew this or not, but that would fall under a felony. So a little gray here. I think there is an argument, like you said, if I was the attorney for the officer, that I would, maybe try to use. I don't think, though, that really applies. I think a later section applies better in this case.
Because even if there was a burglary here, and I'm not sure if they could find that there was a burglary here, because for a burglary, it's not just breaking in. It's breaking in with the intent to either commit a theft or a felony after you break in. And I don't think there's any evidence he was trying to steal something. I don't know if there's some felony that you could attach that he was trying to commit by breaking into his girlfriend's RV. It's possible. So I'm not even sure if they have enough here for the burglary felony. I do think that's an argument, though. But even if they had the burglary felony, is there evidence that he was using a deadly weapon in doing so? Maybe if they thought there was some sort of hammer or something that he was breaking in with, potentially. But it is so much speculation. We're speculating so hard in this situation that I think the officer here would not have anything close, to a probable cause.
Absolutely.
Then 2B is if the officer reasonably believes the individual is attempting to escape by use of a deadly weapon. So here, first we had a felony with a deadly weapon. Second standard is the individual attempting to escape by using a deadly weapon.
I don't think that's applicable in this case.
I agree. Again, we don't have a weapon here that the officer knows about. We know now DPS has done an investigation and they found that Leslie was unarmed during this. We don't know what the officer thought, though. So it's possible that the officer thought Leslie had some sort of weapon for some reason. I just don't see anything in the video that would lead the officer to believe that Leslie had a weapon.
Absolutely.
I think the only way the officer could think Leslie had a weapon is if he was really reading into that prior incident where Leslie said he was going to slit his girlfriend's throat. Maybe he just assumes Leslie carries a knife, or maybe he's just making an assumption. Maybe he just thinks, oh, someone like Leslie would carry a knife, or someone like Leslie would carry a gun. But again, that's not enough here to meet this standard. There's just not evidence here to suggest that Leslie was attempting to escape by use of a deadly weapon.
I would agree with that.
And then the next section, under section C2, is C2C. The officer reasonably believes through past or present conduct of the person, which is known by the peace officer, that the person is likely to endanger human life or inflict serious bodily injury to another unless apprehended without delay. I think that last part is what's really key here.
Absolutely. So like we talked about before, is that this happened actually the day before the alleged incident happened. Officers did try to make contact. They called it off because they said he was driving too erratically, and then they made contact with him. It looks like about 24 hours later. Now, unless apprehended without delay, I think the officer's own investigation really undermines this section or makes this section inapplicable in this case, because the officer did delay, right? Or the officers in general did delay some sort of investigation and apprehension of Daniel Leslie.
Exactly. So we know at this point probably, roughly 24 hours have passed. And I think Leslie proved that in that 24 hours,
he didn't slit her throat, right?
Yeah, he didn't slit her throat. He didn't endanger anyone's lives that we know about, at least. So from the officer's point of view, from what they knew at that time, Leslie had been, out on the run for 24 hours without harming anyone. And so there's actually kind of proof in this case that he's unlikely to endanger human life when he's apprehended with a delay. So here, there's just not enough to meet this standard once again. I feel like as we go through this statute, it's just getting less and less likely here that the officer could possibly justify this shoot. So there's one more section here. It's if the officer reasonably believes it's necessary to lawfully suppress a riot if the person or another person participating in the riot is armed with a deadly weapon.
Not applicable in this case. There was no riot. He wasn't helping somebody else participate in a riot. C2D really misses the mark of what actually happened in this case.
Yeah, it just doesn't apply to this section. So unfortunately, we went through every section here that's really applicable to this case under Arizona law. All these sections that would justify the officer's use of force in a situation like this. And while there are some arguments under a couple of these sections, I know if we were his attorneys, we would definitely be making these arguments. I would be making a big deal about those prior threats to the girlfriend for sure. And I would say, yeah, that definitely gives him justification to believe that Leslie would be carrying some sort of weapon, that he'd be dangerous, that he's likely to harm others. I would definitely make that argument on the officer Sutton's behalf in court. However, would I be likely to win that argument? I doubt it.
I doubt it too. The other thing that the officers could have done is maybe they did contact the victim in this case to talk to her about, any prior behavior, any prior threats that he's made, or since that incident, if he's made another threat to her, stuff like that. Maybe they did do that investigation before they contacted Daniel Leslie, but that's all clear speculation. And even if they did, I doubt that that would raise to this level based on what we saw on the body-worn camera.
Yeah, and today we focused mainly on whether there was a justification to stop Leslie as he was attempting to flee the scene in a way. However, do you feel like there's any sort of argument here that the officer could claim some sort of self-defense, defense of others?
I don't, only because there is no imminent threat to the officer or others, right? I don't think the officer has any articulable facts to state that he thought that Daniel was going to run inside the house and hurt the people that was in there, right? I don't really think there's any argument towards that. And because he got out of the car with his hands and there was no, weapon or firearm that we could see, I don't think that the officer has any sort of argument to say that he was in imminent danger.
Yeah, I agree here. What we know now is that Mr. Leslie's family has pursued a civil lawsuit here. So they are suing Officer Brian Sutton and the Prescott Police Department to hopefully get some sort of civil settlement here. I think they have a pretty good chance here of getting a settlement based on what DPS has found and based on what we've analyzed and what the family's attorney has brought forward. I think there is a strong civil case here. Civil law is not my expertise, but from what I've seen, it looks like a bad shoot, and I think they're likely to get either some sort of success in court or maybe more likely a settlement.
It's a sad situation because regardless of if they win or not, which I think is likely, I think that they will win. We can get Attorney Pierre White in here and talk about the strengths of the civil case, but either way, it's not going to bring him back, right? And that's why being a responsible gun owner, having training, and not getting caught up in the moment is super important, because unfortunately somebody lost their life, right? Like we said earlier, he didn't listen to commands, he didn't stop, but with what we've seen in the body-worn camera, I don't think that's justified in shooting him.
Yeah, and I think it's interesting where we have situations like this where this is not the perfect victim as people describe. This is someone that has some sort of evidence of a criminal past involving domestic violence. This is someone that we know at the time of the shooting was being pretty rude to the officer and eventually not following commands, attempting to flee from law enforcement, doing a lot of things that I do not condone. I do not think this individual was acting properly. However, just because you have an imperfect victim, a victim a jury may not love, does not mean that a shoot is suddenly justified. And I think this is where we have one of those tough situations where we have kind of an imperfect victim and we have an officer that was in a difficult situation himself and was trying to make a split-second decision, but he made the wrong split-second decision here.
In Tennessee versus Garner, the court actually states that, even if that means that people might be able to flee, that's more important, right, than somebody losing their life.
Well, the Fourth Amendment makes it clear that there's a protection against unreasonable searches and seizures. And I know the court discussed the fact that, in a way, shooting someone to stop them from fleeing is
the ultimate seizure.
The ultimate seizure. There's no more serious way to do that by stopping someone's life, by seizing someone. And that's why we have such high standards, for things like reasonable suspicion, for things like probable cause, because we want to be sure that we have a basis in stopping or seizing someone or arresting someone before taking such drastic action. And here we have a case where some action was needed, but it seems like the wrong action was taken by the officer. So we're going to see what happens next here. We know that the case has been forwarded to the Maricopa County Attorney's Office. From our understanding, this occurred in Prescott. So Prescott is actually not in Maricopa County. So I don't know exactly, it hasn't been publicized why Maricopa County is reviewing it. I have to imagine there's probably some sort of conflict maybe with the other county reviewing its own police department's case, or maybe there's too many prosecutors that know this officer, or many other reasons that there could be a conflict on this case. But Maricopa County is now reviewing it. So there is the chance here that Officer Brian Sutton will be charged. If he is charged here, it seems like he'll probably be charged with some sort of manslaughter type of charge, maybe a negligent homicide potentially. They could charge it as a murder. Sometimes we'll see cases like this charged as a murder and then later reduced. So we'll have to see if Maricopa County first even decides to charge, and after that, what charges they decide to bring. But I think it will be interesting to see how they pursue the case and also how he ends up being sentenced. Because I always note that in situations like this with an officer, that it didn't seem like this officer was aiming to go out and kill someone that day, from what we know. It seems like this officer was trying to do his job. He was trying to get Leslie to follow commands at first, and then he made a mistake. However, when you make a mistake so serious, there is reason for punishment. However, I don't think this punishment necessarily needs to be so severe where Sutton's spending, the majority of his life behind bars.
Yeah, we'll have to see how the case turns out, if they do charge him or not. We can keep everybody updated if there is updates in this case moving forward. We are going to be taking a look on the civil side as well. The officer is on administrative leave while this investigation is pending. We'll just have to see what comes from it.
So today, Brittany and I have decided this was a bad shoot. But thank you everyone for tuning in to another legal analysis. We hope to have some more good videos for you in the future. Be sure to check us out at attorneysforfreedom.com to learn all about our law firm, get to know our team, and get to know the types of cases we take. You can also check us out on attorneysonretainer.us. Attorneys on Retainer is a self-defense protection program. Go ahead and check out that website and see how you could become a member today. Also, if you liked this video, you can go ahead and like, comment, share, and subscribe. Thank you again for tuning in. Until next time, this has been attorneys Rachel Moss and Brittany LaBerry. Peace.